The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain how to transfer assets to your revocable living trust. A revocable living trust is a document that we use in an estate plan to make sure that your estate doesn't go through probate. It's a legal entity that can own property separately from yourself. During your lifetime, you are both the trustee and the beneficiary of your trust. The trustee is the person responsible for managing the assets of the trust according to the terms of the trust for the benefit of the beneficiary. So because you're both the trustee and the beneficiary of your trust during your lifetime, your only obligation is to yourself, and you don't notice any difference at all between owning the property in your own individual name and in the name of the trust. And financial institutions understand this as well. They understand that this is basically a legal fiction that really kicks in when you pass away, and there's no complications that are caused by transferring property to your trust. So we want to dispel that fear. But the way a trust works is probate is necessary in Illinois if you own any real estate outside of a trust or own more than $100,000 of non-real estate assets outside of a trust. So what we do is we transfer those types of assets, your savings accounts, your real estate, to the trust so that when you pass away, the executor of your estate or the trustee can say, probate isn't necessary because there's no real estate outside of the trust. There's less than $100,000 outside of the trust, and they can then do away with your estate, distribute it to your beneficiaries as stated in your trust with something called the small estate affidavit. They don't have to go through a year-long probate case, pay attorney's fees, deal with the hassle and headache of that, and wait for a year before your beneficiaries can get your assets. So the goal, again, is to eliminate the need for probate. We do that by appropriately transferring assets to your trust while you're alive so that when you pass away, your estate, which is everything outside of the trust, is small enough that probate isn't going to be necessary and everything can be transferred immediately. So that being said, one, you have to transfer some assets to your trust for it to be effective at all. The trust isn't legally effective until it owns something. And two, you don't have to transfer everything to your trust. We usually recommend transferring any real estate that you own, including timeshare real estate, and any major savings accounts, including IRAs, 401ks, and life insurance policies to the trust. Now, IRAs, 401ks, and life insurance policies we treat a little bit differently, and we'll talk about that in a minute. But if you transfer your major savings accounts to the trust and any real estate you own, you can usually get away with keeping your checking account, personal property, and vehicles outside of the trust, as long, again, as the total assets outside of the trust total less than $100,000, because if it goes over $100,000, anything outside of the trust is going to have to go through probate. Okay, so let's talk about individual assets and how we deal with them and how they're actually nuts and bolts transferred to the trust. So 401ks, IRAs, other retirement accounts, and life insurance policies usually have direct beneficiaries that are named on the account. For this reason, as long as there's a living named beneficiary, they don't have to go through probate. So in order to basically speed up payments from these accounts, if you're married, we usually recommend not putting the trust as the primary beneficiary, but putting your spouse in his or her individual name as the primary beneficiary. Again, as long as they're living, everything will go to them directly, it'll avoid probate, and everything we're trying to accomplish with the trust will still be accomplished. What we do then for retirement accounts and life insurance policies is list the trust as the successor beneficiary, so that if something happens to both you and your spouse at the same time, or your spouse passes away and you forget to change the beneficiary designation, you're going to at least have a named beneficiary that can accept those assets. That's the trust. And it's basically a catch-all safety net. In the absence of naming the trust as the second beneficiary, if your spouse dies and they were the only person named, then everything's going to get dumped into your probate estate. Depending on how you want to do things, if you've got kids, it may make sense just to name the kids as successor beneficiaries. But the reason we want to have the trust there usually is because if one of the kids predeceases you, you want to be able to have their share go to their children, or however you want the terms of your trust layout that's a little bit more intricate than what can be named in a change of beneficiary form. So again, for retirement accounts And life insurance policies, the rule of thumb is usually spouse as the initial beneficiary, trust as the successor beneficiary. And you do this by requesting change of beneficiary forms from the financial institution. You send them a letter asking or give them a call. They'll send those to you. You fill them out, sign them, and send them back. And that can be done without an attorney if you'd like. If you own real estate, this is pretty simple. Just like when you purchased the real estate, there was a deed that was created at the closing that transferred the real estate from the owner of from the name of the previous owner to your name. You will create a deed and transfer it from your name as an individual to your name as trustee of your trust. Your attorney will draft this for you. It's very simple. You sign it, and then your attorney files it with a recorder of deeds to get that on record. And so then the property is now shown as being in the name of your trust, with you as the trustee rather than you as an individual owning the property. And again, you're not giving up any control of this property during your lifetime. It doesn't pose any problems when selling the property later on. If you own a business, it depends on the corporate form of your business, but if it's a corporation, whether that's an S Corp or a C Corp, you're going to want to basically transfer your stock certificates from the name of the corporation to the trust. Now, some types of corporations have restrictions on who can be the owner, so check with your attorney about that. But it's kind of like endorsing a check over to someone else. At the back of the stock certificate, you can endorse it over to your trust and then make a note in your corporate book that those shares have been transferred from you to you as trustee of your trust. If you own an LLC, you do this by updating the operating agreement, and again, you can have an attorney do this for you pretty easily. If you have a bank account that you want to switch over, and again, usually we do savings accounts, but if you keep a lot of money in your checking account, you may want to consider this. You basically just send a letter of instruction to your bank telling them what you're trying to do, and you include a copy of your trust along with that. You really only need the first page, the page that lists the trustees, and the signature page. We call that an affidavit of trust, and include that with a letter of instruction. You can also go in with your trust to the bank and just tell them what you're trying to accomplish. And finally, remaining personal property, other than everything we've dealt with, so these are like physical things like a gun collection or a musical instrument collection. We only worry about this if we think that there's a lot of value in this personal property. So it's usually with large collections. What we want to do is something called a bill of sale, and it's almost like a receipt, and it's a 1 or 2 page document that your attorney can draft up and say, I am, for value received of $10, I'm transferring my entire gun collection from my name to my trust's name, and you put this in the bill of sale. And you don't have to do this, you don't have to detail every particular item of personal property, although you can, but you can lay out categories. So you can say, all of my fine art goes, is going to be transferred to the name of my trust. All of my vehicles, vehicles you can't really do. You've got to change the title on the vehicles. But really any other personal property that you don't have to deal with the DMV for, you can just kind of list out the category of property on this bill of sale and transfer it to the trust. We usually don't recommend doing that just to save you the hassle unless, again, you've got a lot of value in your personal property. And just to summarize, the goal of this exercise is to make it so that when you pass away, you have less than $100,000 outside of your trust and no real estate outside of your trust. So as long as you're doing that, you've done everything right. We want to be extra safe with it, though, while you're relatively young and of sound mind. You want to set things up in a way that things aren't going to spiral out of control if you get old and stop managing your finances appropriately, because whether you become mentally incompetent or you just kind of have other things to worry about, setting up your trust funding situation while you're young makes things a lot easier. So that's why, keep your checking account out, maintain the balance of your checking account below about $50,000, and everything else, even if right now it wouldn't put you over the probate limit, everything else except for the checking and vehicles and personal property, you should probably put in the trust just so you don't have to worry about that later on. So that's what you need to know about trust funding. If you have any questions, you can call us at 630-324-6666. We offer free consultations in nearly every area of law. You can also leave questions in our comment section below this article at learn-about-law.com. We'll try to give you an answer within about 24 hours. You can leave questions on our YouTube channel as well. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and thank you so much for listening.
Thanks for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit makingrealestatefun.com for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation. Thanks for watching.